This evening, we are delighted to have Professor Megan Bowman deliver the inaugural Allen and Gledhill Sustainable Finance Distinguished Lecture. Firstly, let me introduce Professor Ernest Lim, Vice Dean at the NUS Faculty of Law, to give a brief welcome address. Professor Lim, please.
Justice Jeyaretnam, Lord Commonwealth, distinguished guests, ladies and gentlemen, it is my pleasure to welcome you to the inaugural Allen and Gledhill Law and Sustainable Finance Distinguished Lecture. I would like to acknowledge the sponsor of this lecture, Allen and Gledhill, a leading corporate law firm in Asia, for this visionary initiative. I would also like to thank the organizers, the EWBCLB Center for Law and Business, the Asia Pacific Center for Environmental Law, and the Commonwealth Climate and Law Initiative. Our distinguished speaker today is Professor Megan Bowman from King's College London, where she is also the founding director of the Center for Climate Law and Governance, an award-winning scholar and teacher. Her expertise focuses on empirical and transnational analysis of sustainable finance in the context of financial regulation and corporate law. She leads the King's UNEP Research Impact Partnership on legal readiness for climate finance, consults to governments and NGOs on implementing the Paris Agreement, and has been principal investigator on several research grants, including the prestigious Leverhulme Fellowship. I would now like to invite Ms. Kang Yen Yi, a partner from Allen and Gledhill, to say a few words. Ms. Kang, please.
Good evening, everyone. Justice Jeyaretnam, the Right Honourable Lord Commonwealth, distinguished guests, colleagues, and friends. It is my great pleasure to welcome you to the Allen and Gledhill Distinguished Lecture, organized by the National University of Singapore, Asia Pacific Center for Environmental Law, the Faculty of Law, EWBCLB Center for Law and Business, and the Commonwealth Climate and Law Initiative. We are honored to have Professor Megan Bowman with us today to discuss a topic of relevance and importance to many of us here today: law and sustainable finance, more regulation or better relationships. As an alumnus of King's College London and a participant of one of APCEL's and CNCS program, and some of my colleagues like to call me a tree hugger, I'm quite personally invested in this issue of climate change, and I'm particularly excited about today's discussion. I think as we navigate the complexities of sustainable finance, the role of law and regulation becomes ever more critical. But perhaps we'll hear from Professor Bowman on other perspectives on this particular issue. We're very fortunate to have her, a leading expert in this field, to guide us through these issues and this conversation. Professor Bowman's work has been extremely instrumental in shaping the discourse on sustainable finance, and I'm confident that her lecture today will inspire us to think critically about the role of law and the role of different stakeholders in achieving our sustainability goals. Today, in the audience, we have a diverse group of students, of professors, of judges, of lawyers, of in-house legal counsel, of banks, and of investors. And each of you play a critical role in this journey towards sustainable finance. And so your participation in this lecture is not just about gaining knowledge, but also contributing to a collective effort to build a more sustainable financial and legal system and framework. And I encourage all of you to engage actively in the discussion and think about how you can apply the insights gained here to your respective fields. Following Professor Bowman's lecture, we will have a moderated Q&A session moderated by Professor Jolene Lin, and I'm very excited to hear about how we are going to engage each other in our role to play in this topic. Thank you all of you for joining us this evening, and I look forward to a stimulating and thought-provoking discussion. Thank you.
Thank you very much, Professor Lim and Ms. Kang. May we now invite Professor Megan Bowman to take the stage for her lecture. Professor Bowman, please.
Hello, everyone. What an honour to be here, really, to speak at this inaugural event, and for such lively, kind words from Ms. Kang and from Ernest Lim, and to all of you for being here, for taking time out of your day to come here this evening. My heartfelt thanks especially to Jolene Lin and to Ernest Lim and to Zach Go as well, and the team for the invitation to speak to you tonight amidst such illustrious company as Justice Jeyaretnam of the Singapore Supreme Court, Lord Commonwealth of the UK Supreme Court, and so many wonderful colleagues who include Joanna Setzer, Cindy Williams, Sarah Barker, Peter Barnett, and so many more in this room and here tomorrow for the conference. And I also just want to acknowledge Singapore. What a beautiful city, what an amazing island. In fact, a former PhD student of mine who did work on sustainable finance in Asia. Before I came here, she sent me an Excel spreadsheet of all the things I need to do, all the places I need to go, and particularly all the food I need to eat. And that's research skills for you, quite frankly. I'm very impressed with her research skills. But she said simply to me, I want others to love Singapore as much as I do. So I think, job done. So I want to begin with 3 moments in time to focus us. So let's begin with a couple of stories, I guess, to really focus us into the topic of sustainable finance and law and the future as we want it to be. And those 3 moments in time, at first glance, I think will seem quite unrelated, but I'm going to show you that they are in fact deeply, deeply interconnected. All right, so the first moment happened in September 2015. Cast your mind back to wherever you were in September 2015. On this particular night in September 2015, Mark Carney, the then governor of the Bank of England, gave a speech at, I suspect, a very surprised Lloyd's of London insurance dinner, in which he stated that the financial risks created by climate change present the greatest systemic risk, the greatest existential threat of our time to companies and to financial markets. And his reasoning really was that the increasingly wild weather, the 1 in 100 year storm that is starting to happen every 6 months, in other words, the physical risks of climate change, have the capacity to overwhelm insurance markets and to create stranded assets. And at that point, there's the potential for very sudden repricing of assets. And whenever we have sudden repricing of assets, we have market chaos. It tends to lead to collapse in value of entire industrial sectors, and then you get a drastic response by regulators to penalise, prohibit some sectors and reward others, what we now know as transition risk. And then, my friends, you have the next global financial crisis. So that was what has since become a seminal speech known as the Tragedy on the Horizon speech, and is our first moment in time that I want to highlight tonight. The second moment in time happened just a few months later in November of 2015. In a historic, almost miraculous moment, the Paris Agreement on Climate Change was signed. And of course, one of the explicit objectives of that agreement is to keep global temperatures to 1.5 degrees, what we might call the temperature guardrail. The third moment in time happened in March of 2022, when the final scientific report of the Intergovernmental Panel on Climate Change, the IPCC, was released. And that report, for any of you who have read it, and I would hope that all of you have, is a hard read. It gives very stark evidence of our trajectory for a 3-degree world by the end of the century, and that is an unlivable world. There's no financial markets, there's no financial stability, there's no need for commercial law anymore. It's chaos. The upside of that report, and thank the Lord above there is a silver lining, is that that is what we're heading for unless we can reduce global greenhouse gas emissions by 50% by 2030. So in 5.5 years, yes. So 3 moments in time dealing with seemingly very different things, finance, climate, and the science, but actually I put to you that they reveal a very clear interrelationship and even an interdependence between financial stability and economic health on the one hand, and environmental sustainability on the other hand. That these things are, probably always have been, but finally we acknowledge are deeply intertwined, deeply interconnected. And we see this intertwining, interestingly enough, acknowledged in the Paris Agreement. So this is Article 2 of the Paris Agreement that contains its goals and objectives. And so often we talk about the Paris Agreement, but we don't actually know what it is that we're trying to do. Well, it's in Article 2. So where I want your eye to focus is actually on Article 2.1c down the bottom. And you'll see that there are essentially, in a nutshell, there's 3 objectives of the Paris Agreement. One on temperature, the temperature guardrail. The second on adaptation, that it should be getting as much attention as mitigation, building resilience, in other words. And then the third thing being making finance flows consistent with a pathway towards low greenhouse gas emissions and climate resilient development. Now, deciphering the parameters of Article 2.1c, that finance clause, is now on the agenda of the climate negotiations. For the longest time, it went under the radar. For the longest time, no one paid it any attention. No lawyers, no legal academics. In fact, it was business that found it first. So we are now looking at it in the climate negotiations at the upcoming COP and most COPs thereafter, I would imagine. But my argument really is that it's a call to action. A call to action to ensure that all finance, including multilateral aid, public funding, private investment, private market finance, not just niche ESG or environmental social governance activities, but all finance for all things is flowing in the same direction, namely towards green, sustainable and resilient development. Really what we're talking about is fundamental change to business as usual globally. And really that means mainstreaming sustainable finance. That's the future. So there's no longer a division between green finance and all the rest of finance over here. There is simply finance that is sustainable and resilient, and that is the future. And it's also the challenge, of course. And this is all just happening now. It's an astonishingly nascent space, particularly from a regulatory point of view. But what we can say so far is that it's clear that climate change and sustainability is no longer a fluffy, peripheral issue for tree-hugging hippies. Sorry, Miss Collins. It's on the desks of CEOs and directors, especially in financial institutions domestically and all around the world. And this raises questions for us as lawyers, as advisors, as bankers, as regulators, as company directors, as researchers and students, and also as decision makers, so all of us in this room. It also has implications for us as citizens of this planet, alongside so many other sentient beings that do not have a voice and upon which we rely for everything. And it also has implications for us just simply as human beings with hearts, with souls, who will not go quietly or complicitly into a diminished future. And for me, those realizations and my own set of questions have been the driving force behind nearly 15 years of research in the climate law and finance space. And I want to talk to you a little bit about that tonight ahead of some of the deeper conversations that I'm sure will be taking place at the conference tomorrow. So the challenge, and I've hinted at it, and there are plenty, you can take your pick, but I guess one of the things I really want to focus on is the role of law and regulation. And the starting question I found myself asking, and that I was asked by others who are already in the finance, sustainable finance space, which is predominantly economists, with the occasional international relations theorist and geographer. And the question was simply this: well, what's law got to do with it? And that is a question. What is behind that question is the sentiment that if sustainable finance predominantly implicates economic actors, then why can't we just let markets sort it out themselves? Well, the answer to that question was actually given a long time ago by Lord Nicholas Stern, an English economist, in his seminal 2007 Stern Review, and he simply said this: climate change is the greatest market failure the world has ever seen. And there's reasons for why that is so. One of the main ones is that externalities are not integrated. In other words, the costs, the true costs of business, are not put on the ledger. They're not accounted for. And that's done due to deficient cultural norms and heuristics in financial decision-making, mostly. We also have the driving force behind a lot of financial decisions is simply business case logic. And business case logic, I found in my own work, is a double-edged sword. It's something that will drive firms and finance to excel, but never to exceed. Never to go too far ahead of the pack for fear of losing competitive edge. And therefore, really, when we look at the lack of internalization of externalities and the shortcomings of business case logic, markets fail often to allocate resources efficiently, and they certainly have failed in the face of the climate crisis. The other pertinent issue is that when the self-interest of firms conflicts with societal public interest, the latter will lose out. And we know that that brings socially dire consequences. We just need to cast our mind back to the 2008-2009 global financial crisis to know that. And we see this in the climate space in a very poignant speech, actually, at COP26 in Glasgow in 2021, a COP that I attended. Vanessa Nakate, the Ugandan activist, gave a really very moving speech. And I have excerpted part of it on the slide there. She said this: we don't believe that banks will suddenly put trillions of dollars on the table for climate action when rich countries have struggled since 2009 to raise $100 billion. I'm here right now to ask finance and business leaders to show us your faithfulness. I'm here to beg you to prove us wrong. And what she's talking about here is trust, the issue of trust, and that is a relational word. And it's necessary corollaries of justice and equity. These are invisible issues, but nonetheless they are at the heart of the climate finance space. All of this means that the fact is that markets need to be regulated and they need to be governed by legal and regulatory institutions to do the right thing and to achieve public interest objectives like financial stability and like addressing the climate crisis. And in addition to policy responses, we also need domestic and regional law and regulation to set out the rights and responsibilities of regulated firms, to create and to govern markets, especially new markets, and to steer economic actors and activities via incentives, penalties, and also norm setting. Importantly, in the sustainable finance space, focus needs to expand beyond increasing green to also reducing polluting finance and transitioning hard to abate sectors. And that for sure is going to require legal and regulatory interventions. So, now that we understand that there is a really important role for law and regulation, it tends to beg the question, well, what law and regulation have we already got? And what do we need? And what needs to be redesigned to become fit for purpose in this brave new world? And certainly a massive impetus of my work has been guided by those kind of questions in order to provide a much needed, what I call regulatory voice in the sustainable finance discourse. So one of the big projects that I worked on a number of years ago was born of a research partnership on legal readiness for climate finance with the United Nations Environment Programme, UNEP. And for that project, I investigated legal and regulatory architectures that can help finance to flow at scale to where it's needed. And that led to the creation of what I called a legal analytical framework to identify and make explicit a palette of regulatory options and legal forms that could help national decision makers to mobilise more finance for sustainable activities. And the framework really embodies two central motifs. This is the first motif, which is a typology, a twofold typology of regulatory tools for climate finance, sustainable finance, termed as, in the red there you can see, financial mechanisms. And really they were the regulatory tools that were clearly directly responsible for mobilising and leveraging capital. They often had dollar signs in front of them or produced directly dollars. And in the purple, what I came to term facilitative modalities. Just trips off the tongue there, but I love the alliteration, you know, the financial mechanisms and the facilitative modalities. And they enable sustainable finance by improving technical capacity and knowledge and know-how and informational streams between and amongst key stakeholders. So what became really clear to me through this project is it's not just about individual financial instruments, but also, you know, there's a whole suite there, and then also these enabling modalities that really can facilitate finance to flow at the scale that we need it to flow at. And really importantly, this work revealed that both types of regulatory tool, financial and facilitative, both of them are essential, and both of them are complementary to each other. And at the time, this was quite a finding because those enabling instruments, facilitative instruments, had never really before been considered as essential ingredients of green or climate sustainable finance. But the data from the research showed so clearly that they are. And indeed, that category of facilitative modalities is only growing. This is a snapshot from my 2018 work. Well, now we can add to it. We can add taxonomies. We can add transition plans. We can add due diligence legislation, all of which is coming down the pipeline. So that, the purple is really critical, actually, really crucial to ensuring that the mechanisms in red are doing their job and doing it at the scale required. The second motif of this work was really what forms do these different tools take? And in doing that work, it was quite clear that they take a plurality of legal forms, multiple legal forms. Not only do they include black letter law, such as particularly we find in tax legislation or corporate law statutes, but they are also becoming very visible in a range of financial market regulation. So, for example, central bank directives to supervised firms, you know, disclosure reporting regulation, which I'll talk about more in a few moments. That middle bucket, really, the regulatory bucket, is really key. So it needs to be in the discourse as well. And of course, also legal contractual agreements, especially for insurance and multi-sector collaborations. And then the third key finding out of this work was that what I call an integrated regulatory framework is required. In other words, there is no silver bullet, and there is no perfect piece of legislation that will do the heavy lifting, that will solve the climate crisis for us. The idea of an integrated regulatory framework really is a complementary mix of the financial mechanisms and the facilitative modalities. And this is probably, you know, still quite rudimentary. I'm sure that we could make that even more sophisticated and complicated, but it's quite a nice visual, I think, to show that this mix is what's going to be required to adjust, or even in cases where required, reform a country's legal and regulatory architecture to account for climate change and to enable greater flows of climate finance. And this idea of a carefully designed multi-instrumental approach, that in the words of regulatory theorist Professor Neil Gunningham, the idea of it is that it can create a web of regulation that's more resilient and more effective than its individual constituents. And I think what's so exciting about this work is how it helps to make the invisible to become visible for decision makers. So in making these tools and the different forms that they can take and the kind of mix that we may need, and the mixes will undoubtedly depend on local context and country context. But in being able to see this, like a deck of cards that's been fanned out, decision makers can actually make quite conscious choices, systematic choices for their local context. So that's the setup. Where to now? Well, interestingly, of all those financial and facilitative tools that are on the slide back here, thus far, the predominant regulatory response has been reporting and disclosure in the facilitative modalities. And it is something that I call the disclosure zeitgeist. It's born out of the Task Force on Climate-Related Financial Disclosure, the TCFD recommendations that were released in 2017, essentially a project of Mark Carney, together with Bloomberg. And those recommendations really were, well, companies need to start identifying and managing climate risk to their business and disclosing it to the market. And since 2017, we're now beginning to see a whole cascades of mandatory TCFD-aligned laws and regulations around the world, particularly in the UK, in Europe, and in Asia. And if you can see on this slide from the source Sustainable Fitch, columns 2 and 3, both dealing with disclosure. The green is for laws and regulations that have been adopted. And so you'll see, particularly in column 3 of ESG disclosure, that's pretty much around the world. The blue dot is what's mandatory, and the yellow is in progress. So we can certainly see that Europe and Singapore are leading the way here, along with several other ASEAN countries and Hong Kong. So in some way this is good. We see a bit of movement, which is good. In fact, we're seeing a lot of movement, really, in the disclosure and reporting space. And this is where I want us to pause for thought for a moment. So in a socio-legal study for a Leverhulme Fellowship that Ernest mentioned that I undertook in 2022, so a couple of years ago, I investigated the levers and the limits of these informational regulatory tools and focused particularly on the leadership role of financial regulators and central banks and also governments. I was using the UK and EU as a case study, but nonetheless was able to extrapolate implications for systems change and the future of the planet, really. So importantly, I found that there were paradoxes that regulators must navigate. And paradoxes are super tricky little things. They require us to hold two quite conflicting ideas in our mind at the same time. And as humans, we don't like that. It makes us incredibly uncomfortable. It's very hard for us to handle. And it's even harder, really, for business to understand, because business just tends to want certainty and solutions. But it is really important to acknowledge that paradoxes exist in this space. And it was something that Mark Carney identified back in 2015 with his Tragedy of the Horizon speech. Paradoxes exist. And particularly as researchers, I think it's quite important to articulate them to help CEOs and also regulators navigate the complexity of this new field. So our paradox in relation to disclosure is this: it is key to the transition, for sure, but myopic focus on it will undermine the transition. Now that's a huge statement. I understand that. So let me talk you through it. The first place, I think, is to start with the theory or the logic of disclosure. And I like to think of it as a trident with 3 prongs. And the first prong that you can see there in orange points to the macroeconomic level. And that's really the risk to financial stability that Carney was describing back in 2015. At this level, disclosure, more reporting, especially about health of companies into the market, enables regulators to evaluate the status of market health generally. Prong 2 in the green points to the meso-market level. And that really is where information transparency is so important for investors. That investors can access accurate information to help inform their capital allocation decisions, and that in turn helps to inform asset prices, of course. And then prong 3 in the blue points to the micro-firm level. In other words, this is simply making the externalities that I mentioned earlier explicit. And the idea here is that through disclosure and the process of doing the reporting, that a firm or a financial institution itself can see its own inputs and outputs and impacts, and therefore begin to make informed decisions about where change needs to occur within its business and its supply chain. Thus far, prongs 1 and 2, so the macro and the meso, have been driving regulatory interventions around the world. Much less focus has been given to prong 3, this micro-firm level prong. But interestingly, that perhaps is the prong that holds one of the keys to the success of disclosure. Certainly the respondents in my Leverhulme study were very clear, and the respondents were central bankers and financial regulators. They were very clear that deep behavioural change, cultural change, business cultural change is most likely to occur actually through prong 3. And all respondents in that study in the jurisdictions that I was looking at, which was the UK, France and the Netherlands, agreed that that kind of behavioural and business cultural change is what will indicate regulatory success in this area. Whereas some kind of tick box compliance approach would actually signify regulatory failure. So that led me to ask myself, so what is the, how can we best leverage disclosure, and where do we need to be a little suspicious of it? Levers and limits. And as you can see on the left, the levers there, I'll highlight just a few. It's best when disclosure is mandatory, research has shown. It is also a logical and necessary first step or a building block for subsequent regulatory interventions. Information is often key to what comes next. But you can also see on the right side there the limits of disclosure, and I think we need to be super clear about what they are and explicit. Certainly the legal form, if it's not mandatory, is a problem. And also, interestingly, various studies have shown that comply or explain reporting can often be deficient as well. That it can lead to quite inconsistent reporting and inconsistent quality of data. The UK Financial Conduct Authority, the FCA, has produced that research itself. Some of that research has come out of NUS here in Singapore, and one of my former PhD students, Felicia Liu, who I mentioned earlier, who loved Singapore so much, her work has focused a lot on the shortcomings of disclosure in different jurisdictional contexts. All of this means that there are benefits of disclosure, which is great, let's leverage them, but there are limitations to reporting and disclosure, and the short answer is this: we cannot green, as one of my respondents in my study said, you cannot green the whole financial system just through disclosures. So in summary, the data reveal a really sobering message. Disclosure in and of itself must not be conflated with a successful regulatory outcome. And what I mean by that is this: merely producing more and more reports and throwing larger quantities of information of dubious quality out into the market, especially without meaningful interpretation of those data or engagement with the providers of those data to gauge the green credentials and to evaluate the greener outcomes of particular financial products, that behaviour is not going to successfully address climate risk to business or business risks to the planet. And in fact, such an assumption that disclosure reporting by itself can do that is, I would say, extremely dangerous, because it creates a veneer of doing something whilst obfuscating the real level of change actually required and potentially crowding out and closing down complementary tools and the tough decisions that we are going to have to make. And that would sound the death knell for effective and timely systemic change for a net zero transition. So that raises the obvious question: what more needs to be done? And as you can see from this visual, fulfilling the promise of disclosure is going to require a lot more regulation. So as you can see on the right-hand side, in the slightly blue columns there, disclosure needs to be nested in a regulatory matrix of complementary tools to fulfill the net zero promise. So this goes back to the integrated regulatory approach that I mentioned earlier, arising from the UNEP research, and it puts it specifically in the context of sustainable finance and law and the tools required. And of the regulation that's coming or in progress, I want to focus particularly in on transition planning as the next critical step. And it's listed there under mandatory disclosure in the second box on the right. So, about this time last year, actually, the UK Transition Plan Task Force released its framework for transition planning, which you can see on the screen there, aimed particularly at companies, and it is a framework that is set to become the global standard, a number of entities working in the space. Certainly, Singapore's Monetary Authority has also released proposed transition plan guidelines for public consultation, again around this time last year, with some excellent commentary by the Asia Pacific Centre for Environmental Law in collaboration with the UN Global Compact Network Singapore in June of this year. And so far, really, the focus of transition planning has been companies and financial institutions, which is absolutely appropriate. I need to say that up front. But you know what? Transition planning also implicates governments through national transition planning. And we're beginning to see pressure, kind of external pressure for this to be happening. If we think about the Swiss senior citizens case, which was a decision that came from the European Court of Human Rights in April of this year, which held that the Swiss government's failure to rapidly cut greenhouse gas emissions is a violation of human rights. That case is essentially a case about transition planning at the national level. It's really about carbon budgets and the steps that governments need to take to make sure that they can implement the science, the IPCC reports in 2030. And in fact, that judgment goes so far as to set out 5 criteria of what a government ought to do to begin the transition planning process. Similarly, the UK High Court in May of this year handed down what I call the High Court Carbon Budget case, in which it held that the UK government's climate action plan is in breach of its own UK Climate Change Act. And therefore inadequate to meet legally required net zero targets by 2050. In other words, the UK now needs to design and adopt a robust national transition plan. And we see similar cases on these topics increasing around the world: Austria, Germany, Norway, Australia, Peru, Brazil, South Korea. The list goes on of places where similar kinds of cases are being launched and listened to. And so the message is clear: yes, companies and financial institutions need to be engaging in transition planning, but so do governments. And in fact, governments really need to take the lead so that company transition plans can be nested into a whole of economy approach. And this is something particularly that myself and a group of researchers from LSE in the UK, the World Bank, Aviva Investors have been investigating. The next step being national transition planning as a sort of an architectural design or pathway for company transition plans, so that you have company transition plans and national transition plans feeding into each other and informing each other in dynamic feedback loops. And for this to work, this is going to require, amongst other things, whole new levels of internal coordination and external cooperation for both firms and also governments. And this is raising some questions as to how. But I would argue that the answer is already within the TPT framework. I mean, if you look on the screen there, one of the 3 keystone principles. So the principles in grey being ambition, action, and accountability. One of those principles is accountability. And it's there in connection with good governance. And I want to hone in on that now and link all of this together. Interestingly, the initial release of this framework was quite thin on the accountability dimension. Certainly mentioned that there need to be clear roles and responsibilities for the delivery and oversight of transition plans, and that those plans need to be reviewable, but it doesn't go so much further. But it's something that I've been thinking about with my colleagues, as I mentioned, in our work on taking the lead for climate action and sustainable development. And this is a rough and ready table of some of the things that we've been thinking about in this space. And I guess what I want to point out here is that so often we synonymise accountability with litigation. Something that I'm sure we'll discuss in depth in tomorrow's conference and maybe later tonight. But I really want to highlight right here and now that they're not the same thing. Accountability includes, but is much broader than, litigation. And what I want to put to you tonight is that there are actually many places and pathways to and for accountability. And when we can understand that, suddenly our approach to transition planning, particularly as a business, can broaden in quite positive ways. And I guess what I'm putting to you is really to regard transition planning as an opportunity for relationship building. So I want to focus on the text in green here, that third column. These are the non-litigious spaces in which I've identified that accountability can actually occur in really quite beneficial ways for both business and for governments. And these internal and external places and spaces show the inflection points for relationship building, and they really are to be encouraged. They can facilitate communication and understanding through transparency and dialogue. That in turn can facilitate alignment for more expeditious and ambitious actions across the value chain through far less conflictual means than litigation. And in fact, I have argued in the report that we've produced that it could even be a litigation mitigation tool. So for business, we see it manifesting in what I call internal ecosystems, so between the links in the investment chain, so investor engagement, shareholder resolutions, beneficiary engagement, and also within a firm, so things like employee engagement and really robust internal board deliberations with directors holding each other accountable in meeting. And then we also have external ecosystem accountability processes, meetings, one-to-one meetings, regulatory engagement, risk-based compliance regimes. There's a particularly good bit of regulation in the UK for central banks called the senior management regime, which actually allocates responsibility for climate risk to a named individual in every single bank that is supervised by the Bank of England, with quite serious professional repercussions if that risk is neglected. The regulators in the space have told me that it's one of the most effective regulatory tools that they've ever developed for putting climate risk on the board of directors' agenda items. We also see these non-litigious spaces for governments, particularly through peer accountability as well as stakeholder engagement. In other words, is your central bank talking to your treasury? Is your finance ministry talking to your environmental ministry, your labour ministry, your transport ministry, your education ministry? Are they all on the same page? Are they having monthly phone calls about these issues? And are they keeping each other supported and informed? Think Article 2.1c of the Paris Agreement. Everyone and everything is heading in the same direction. And this really will be crucial for effective implementation of transition plans. The good news is that the necessary coordination and cooperation, whilst it is slightly challenging, because up to this point we have tended to think in silos, we tend to work in silos even within governments and within the firms, examples of coordination and cooperation are beginning to emerge around the world. And I know, for example, that with discussions with the Monetary Authority in Singapore, that Singapore is starting its transition plan journey with an eye on intergovernmental coordination. And also in my Leverhulme research on financial regulators in the UK and EU, the data revealed what I call regulator ecosystems for sustainable finance. And what that means is that cooperation is happening between these different agencies and ministries within the government as a collective response to a complex challenge. And you can see a quote from one of my respondents there in blue, who said, and this was a financial regulator, coordination is key as an individual regulator and to the larger goal of the vision to making this work. And these emerging regulator ecosystem responses are laudable and they are exciting for two main reasons. First, they are going to be essential for countering the inherent complexity of systems change and ensuring timely and strategic action to facilitate economy-wide transitions. But second, they also bring into the sustainable finance space much needed attention to the relational interconnectedness that we so desperately need in order to move forward. And this is key because to my mind, the planetary crisis is a relational crisis. And to evidence that assertion and to wrap up this presentation, I'd like to share with you some personal reflections about undertaking the various research projects that I've walked you through tonight. So during this research, during these various research projects, a number of things were happening in the world. The IPCC report's findings had come out, and as I mentioned earlier, that's a hard read. Plenty of tears have been shed over reading that particular report. Externally in the world, massive increases were occurring, still are, in heat waves, wildfires and floods, and the COVID pandemic and the energy crisis out of the Ukraine war, for those of us in Europe, shone a very bright light on system vulnerabilities and our lack of readiness. to meet net zero and sustainable imperatives. So I found, to my surprise, that I needed to do this work at a pace that allowed for what I came to realise was grieving. Yeah, and that was really unexpected. And it was kind of tough because it slowed me down, you know? And I was just used to go, 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 like everyone I would imagine in this room, just go, go, go. And I found that I couldn't just go, go, go with this work. But as Dr. Martin Shaw, the British mythologist, writes, the deepest stories always want you slower, more deliberate. And this really hit home for me after drafting particularly that Leverhulme report of my research findings in July 2022. Shortly after producing that report, I was scheduled to go to the Law and Society Association conference in Lisbon. And I decided with a colleague that we would be incredibly net zero responsible, and we'd catch trains all the way from London to Lisbon. And at the time when we were preparing, it was exciting. It was a girls' own road trip via train. And I wasn't paying too much attention because I was so busy. But actually, just before we were meant to catch the first train, my colleague, my friend, Alexandra Jordanowska, an excellent regulatory theorist in her own right, messaged me and said, I've got COVID, I can't come. I'm like, oh, okay, so I'll be doing this on my own then. In hindsight, I'm glad I was on my own because there were a lot of low points in that journey. I'm glad that she didn't have to see them, quite frankly. Essentially what happened is to get from London to Lisbon by train, it's a lot of trains. It's not some beautiful Oriental Express that you jump on and you crack open your champagne, and many bottles of champagne later, you have arrived magically at your destination, fabulous and free. Actually, it is just a bunch of suburban trains. So trains for like an hour, 2 hours, 3 hours maximum. Once you get off the Eurostar, it's just suburban train after suburban train across 3 or 4 countries. That in itself is a tough ask. But at the same time, one of the most dire heat waves that Europe had ever experienced was happening with temperatures in the 40s, 40 degrees Celsius and above. There was a ring of fire around the city of Lisbon, a forest fire, wildfire that had broken out because of the extreme heat. And at a certain point in the journey, I started receiving emails from the Portuguese government saying the trains don't work. So I actually had to abandon that plan, and I can't say I was sorry, because by the time, by San Sebastián, by Spain, I was beside myself. I was exhausted, and the heat was incredible, and as the trains broke down, literally so did I. And had to eventually jump on a plane from San Sebastián to Lisbon. Due mostly just to institutional, the fact that we just didn't have the infrastructure under those conditions. And really, by the time I reached Portugal, I was worn down, and I guess the reality of the mess that we've created for ourselves really hit home on a personal level. But there's an amazing Indigenous botanist, a woman by the name of Dr. Robin Wall Kimmerer, and she has written incredible work. If you ever need to be inspired and moved, please read her work. And she says this: grief is not the same as despair, but rather it indicates connectedness. And the philosopher Joanna Macy, she says it's a sign of spiritual health and a necessary precursor to falling back in love with the planet again, something that is so desperately needed at this time. So after that Lisbon conference, I went to a part of Portugal called Cascais on the coast, and every day I swam in the cold Atlantic Ocean, and it is cold, cold water. And every day while doing breaststroke through those icy, clear blue waters, I wept into the sea that surrounded my body and that gently entered my eyes and my mouth. And as the hot salt water of my tears mingled with the cold salt water of the sea, I felt humbled and I felt held. And with gratitude and with grief in equal measure, I would sing to the water and to the sky an excerpt of old Norse literature from the Poetic Edda, an excerpt that speaks of the beauty and the ever-presence of the world tree, known in their tongue as Yggdrasil. And as I merged with water every day, I felt physically, somatically, what my biology textbook had told me back in high school, that I am an inextricable part of nature, that we are one organism in the ecosystem of life. And I've talked a lot about ecosystems tonight, of regulators, internal and external, but we, in the bigger picture, we are all part of the ecosystem of life. And I really had to take my own research findings to heart. You know, no one actor can solve the climate crisis. Me catching trains from point A to point B or not is important, it's helpful, but it's not going to solve the climate crisis. This is an institutional issue. And it is a crisis of relationality and interconnectedness. So it seems to me that a relational approach to life, which includes coordinative approaches to sustainable finance regulation, and which includes how we connect to and treat each other within a democracy of species, is the most sensible approach that we could take in a world that so desperately needs to be viewed in new ways through new eyes. In law and in finance, we're taught to be neutral, objective, and above all, reasonable. But I really am beginning to believe now that head and heart alignment is what is required if we're to have a future that's worth living. And this is something that gives me hope. In the words of Robin Wall Kimmerer, and I quote, "Here is where our most challenging and rewarding work lies, in restoring a relationship of respect, responsibility, and reciprocity, and love." Thank you.